welcome today to UNH Franklin Pierce, and honestly to our first in-person kind of event like this for the Redmond Center in, I think, 2 years, almost 2 years. So I was just saying, you're going to have to forgive if we, our awkwardness with, with peopling, and we are just overwrought with enthusiasm and delight to have all of you here with us today. It's my belief that legal education it takes many forms. It doesn't just happen in the classroom. It's critical that we engage with the community, that we have a site of debate with a multiplicity of perspectives, that we're hosting events like this, and that we are a site for dialogue about all of the important issues of the day, and that we are promoting justice and leadership at the same time. That's really why we're here today, and it's what this afternoon is all about. Welcome. We're happy that you're here, and I have the absolute pleasure of introducing to you today Professor John Graby, who likely for many of you needs no introduction at all. But we have him to thank, and the Redmond Center, including its fantastic advisory board, to thank for this event this afternoon. John's been directing the Redmond Center for 3 years now. Is that right? Yeah. And, he uniquely is committed to students. He is a phenomenal writer, not just in law reviews, but if you haven't been aware of his columns in the Concord Monitor, you should absolutely check them out. He has an incredible ability to boil these very complicated legal concepts down into terms that are digestible, and able to be articulated for all people. He's one of my very favorite guests on public radio and locally. And he has really grown the Redmond Center over the last few years. Come on in, sit down. He has really grown the Redmond Center over the last few years. It is a constant area of dialogue and debate here, with events going on, whether it is virtually or in person. He is also the kind of colleague that everyone should have, and he makes me laugh all the time. So thank you so much, John, for all you do for this school and for our students. And I'll just go ahead and hand it over to you. Thanks so much.
I had a moment of panic as I thought I left my glasses upstairs, but I'm okay. So Megan, thank you. That was, as usual, overly kind. As Megan just shared, my name's John Graby, and I direct the Warren B. Rudman Center for Justice, Leadership, and Public Service here at the UNH Franklin Pierce School of Law. We are so excited today to mark Constitution Day by welcoming to campus Adegbile, who will be sharing reflections on our nation's ongoing fight to make our democracy an inclusive democracy. Attorney Adegbile chairs the anti-discrimination practice at the WilmerHale law firm in New York City. He also serves as a commissioner of the U.S. Commission on Civil Rights, to which he was appointed by President Barack Obama in 2016. He began his career as a commercial litigator at the New York law firm of Paul, Rice, Rifkin, Wharton, and Garrison. In 2001, he joined the NAACP Legal Defense and Educational Fund, where he served as Director of Litigation and Acting President and Director Counsel. While there, he argued 2 major Supreme Court cases defending the constitutionality of the Voting Rights Act of 1965, Northwest Austin Municipal Utility District No. 1 versus Holder, and Shelby County versus Holder. In 2013, he was appointed senior counsel to the Senate Judiciary Committee. He is also heavily involved in community and professional service activities. He is the chair of the Connecticut College Board of Trustees and vice chair of the Vera Institute of Justice's Board of Trustees. He also serves on the NYU School of Law's Board of Trustees, the Center for Democracy and Technology Advisory Council, and as the University of the District of Columbia School of Law, Joseph L. Rao Chair of Civil Rights. He is a graduate of the NYU School of Law and Connecticut College. Please join me in extending a warm welcome to today's guest, Adegbile. Thank you.
Thanks so much, John. It's wonderful to be here with you. It's wonderful to be at a live event. I think, as Dean Carpenter said, we're all trying to relearn our social skills. That goes not only for those of us who have missed our start at kindergarten and everything else during the pandemic, but even for those of us who are a little longer in the tooth. We're trying to figure it all out again. It's really, really great to be here with you today to talk a bit about the topic of voting rights and democracy on this Constitution Day, which is what brings us here together. And I thought what I might do today is to put some things in context and offer a little bit of a historical perspective on the longstanding struggle to extend and protect voting rights in America. And my take on this subject today will be informed by some of the work that I have done litigating cases trying to navigate these issues, which, as we have learned, are issues as present today in some ways as they were in the history books as we have read. I want to talk a bit about Selma today also, and you may be thinking, Selma, Alabama, anytime somebody talks about voting rights, Selma figures rather prominently. It's a really important piece of voting rights history. But in some ways, I think that Selma, Alabama, even with all of the attention, may be an underappreciated piece of significant American history in voting rights. And today I want to explain why. Selma figured very prominently in the fight to break with the grip of slavery, segregation, disenfranchisement, and for the quest to embark on making the United States a transformative joining a transformative journey to make it an inclusive democracy and to protect voting rights. But when you hear these words, when I say these words, I'm quite sure that all of you have thoughts that are turning probably to the Edmund Pettus Bridge, to the famous Selma to Montgomery March, to the work of John Lewis, the work of SNCC, the SCLC, Dr. Martin Luther King. Perhaps some of you know Amelia Boynton, the woman who in the trench coat was famously knocked unconscious on the bridge, and the photos of people grabbing her as they're trying to comfort her after the assault of Sheriff Jim Clark. And we are going to talk about all of that today. But that period in time, that Edmund Pettus Bridge moment, they're indelible moments in our history. But I'm not going to start there today. When we talk about Selma, I'm not starting there. I'm not starting there for a very intentional reason, and a reason that I think sets the long journey for enfranchisement in a broader context. Today, I want to take you back to not the Selma of 1965, but rather to the Selma of 1865. That was the last year of the Civil War, and Selma, as we will discuss, helped to place the later Voting Rights March in 1965 in motion, and helped to establish that bridge, that march, that place as a very historically significant one, as being a bridge to freedom. And so we begin with the Civil War because most of the history of voting rights in America is about that war, its long and pernicious shadow, the struggle to mend the civic and political breach left in its wake, and the constitutional rights that were born out of that conflict, as African Americans and others insisted that the nation live up to promises too long denied. Abraham Lincoln regarded the promise on the other side of the Civil War, as some of you may know, as the new birth of freedom. And in many ways, as we would learn in our democracy, we must fight for the many births and lives of freedom, as the promises of new freedom are always contested and too often not fully met. Selma, Alabama was founded in 1820. It was not a big city when the war broke out in 1861, but it was a wealthy agricultural center. Over the course of the war, Selma became the second largest hub of Civil War materials and manufacturing and distribution for the Confederacy. Located near the Cahaba River Valley, Selma was in a position to take advantage of the nearby woodlands and plentiful deposits of coal and iron. By some accounts, by the last year of the war, the factories of Selma produced between a half to 2/3 of the munitions and supplies used in the Confederacy. In 1865, the tide of the war had turned in the Union's favor, and the Federal troops were making their way deep into the Confederacy. General Ulysses S. Grant was making inroads against Robert E. Lee in Virginia, and General William Tecumseh Sherman had concluded his famous March to the Sea. He'd captured Savannah right around Christmas in 1864. And in the Tennessee River Valley, there was the Union's Army Cavalry Corps, the largest and best equipped cavalry force of the entire war, led by Brigadier General James Harrison Wilson. In March of 1865, Wilson crossed the Tennessee River into northern Alabama. And by April 2, 1865, Wilson and his 9,000 battle-tested troops arrived at Selma. At this point in the war, there were about 1,500 Confederate soldiers in Selma, so the Confederate generals in charge used local militias and pressed Selma citizens into service to fight for the Confederacy. The two Confederate generals at Selma were Lieutenant General Nathan Bedford Forrest and Lieutenant General Richard Taylor, the only son of the 12th President of the United States, Zachary Taylor. Forrest was infamous, as some of you may know, for the massacre at Fort Pillows in April 1864 in Tennessee, when his troops opened fire on surrendering Union soldiers. Reportedly, some 300 black soldiers were killed. Fort Pillows is considered one of the most controversial events in what we know was a very bloody and difficult civil war for our country. The result of the Bedford Forrest-led massacre and killing was that rather than capturing surrendering prisoners of war, the North ultimately refused to participate in prisoner exchanges, and this helped forge Bedford Forrest's reputation as a particularly brutal combatant. So the Battle of Selma was part of a crucial campaign, and historians have called it Wilson's Raid, which allowed the Union Army to target the industrial and manufacturing capacity of the Confederacy in order to bring an end to the war. Reportedly, the Union Army lost 359 men in that battle, and the Confederacy lost over 2,700. The battle itself, however, lasted less than a day. The Union forces overwhelmed the Confederate troops and overran the 3.5-mile horseshoe-shaped fortifications protecting Selma in the north. Wilson's troops marched eastward to Georgia after Selma. They fought and captured Columbus, Georgia on Easter Sunday, the same day that President Lincoln was shot. The Battle of Columbus was the last battle of Wilson's raid, as Columbus was one of the last Confederate cities standing. And some historians also consider this to be the last real battle of the Civil War. Days earlier, General Lee had already surrendered at Appomattox Courthouse, and the big question was how long the Confederacy could last. After Columbus, Wilson and his forces set off to find and capture the most wanted man in America, Jefferson Davis. Within a few weeks, they would succeed in capturing Davis and ending the war for good. So why do we pause? Why do we reflect on this Battle of Selma? Why do we talk about it? The Battle of Selma was a key marker in the defeat of the Confederacy, and it's regarded by some as the first march to freedom. That's because many slaves literally followed the Union soldiers as they marched to Montgomery out of Selma at the time of the Battle of Selma, after those battles. And so in some way, this battle that was 100 years before the one that we think of, the Civil Rights March that had history meeting on that bridge, on the Edmund Pettus Bridge, was preceded by this extraordinary and very important fight in the Civil War itself to end the institution and imposition of slavery in the country. And very often we talk about Selma and the Edmund Pettus Bridge, but I don't think we put it in that historical context. We'll come back to that, but I want to talk a little bit about what happened thereafter, because this is all part of the story of voting rights. And Alex Kesar has written a very important book about the history of voting rights in America called The Right to Vote. And in that book, he explains that voting in America, that the dominant narrative is that America is a nation conceived in democracy, and that we march ever forward, ever toward progress, that progress is inevitable, and that we keep marching forward. But when Kesar examined what the experience was and looked at the historical record in voting, what he saw is that the record is much more characterized by ebbs and flows, progress met by retrenchment, and that cycle is what he found the history to reveal more than an inevitable march forward and an ever-increasing expansion. And so his book sort of pushes back on that narrative. So what happened after the war and in the Reconstruction period? Congress sought to enfranchise millions of recently emancipated citizens and to ensure that they could exercise their right to vote. The Reconstruction Amendments, as you all know, were crucial to this goal. Adopted between 1865 and 1870, the 13th Amendment abolishing slavery, 14th Amendment, which granted equal protection and due process, and 15th Amendment, which forbade discrimination in voting based on race or previous condition of servitude, extended the civil and political rights to all citizens regardless of their race. More than 100 years later, on the occasion of the centennial of the Constitution of the U.S., Thurgood Marshall reflected back on that time and that moment with these words. It took a bloody civil war before the 13th Amendment could be adopted to abolish slavery, though not the consequences slavery would have for future Americans. While the Union survived the Civil War, the Constitution did not. In its place arose a new, more promising basis for justice and equality, and yet almost another century would pass before blacks could have their votes counted. And so Thurgood is looking back at that period. You can see that his theme on the centennial is sort of or that actually must have been the bicentennial. I need to check my math there, but I don't want to make Thurgood older than he was. But the point here, nevertheless, is that Thurgood Marshall is reflecting on that conception of a rebirth, of a new birth of freedom, like Lincoln's words from the Reconstruction, right? Like he essentially he's saying that the Constitution didn't survive because it's his understanding that the Reconstruction Amendments, these amendments of which I've just spoken, transformed the baseline document and provided a new basis on which to go forward, whereas the earlier version of the Constitution had built into it these flaws that in some ways set us on the path to have that civil war, right? And so he's sort of drawing a discontinuity and coming to that idea of rebirth. In the Reconstruction era, the reaction from groups like the KKK that resisted the premise that the Civil War had ever ended and that the viability of slavery was past and that racial caste was behind us led to a brutal campaign, as you well know, of intimidation and violence that was imposed on blacks throughout the Deep South. And the leaders of the Confederacy, many of them were, continued these fights. There's some of the folks that had led the Civil War battle. Recall the two commanding Confederate generals that I spoke of from the Battle of Selma, Taylor and Forrest. Both escaped the battle with their lives. Taylor moved to New Orleans and became financially successful and entered politics, and unsurprisingly became a vociferous opponent of the Northern Reconstruction efforts. And Nathan Bedford Forrest, whose military fate was sealed in defeat in Selma, continued his resistance as well. He lost the battle, but he continued his war. How, may you ask? Forrest ran into financial troubles after the war. He had exhausted much of his personal fortune during the war, and the abolition of slavery had a big impact on his finances. In the late 1860s, he became involved and later served as the first Grand Wizard of the KKK in 1866. So again, I want to take you back to Selma and understand how central this place and this moment and the fights and the battles were in everything that followed in voting and in trying to continue the racial caste that was not consistent with the inclusive democracy that we aspire to be. Forrest would deny his association with the Klan when he was called to testify about it in front of a joint committee of Congress in 1871. But he served as president of the Selma, Marion, and Memphis Railroad Company, a business that failed in 1874, and he became a manager of a plantation that used prison labor until he died in 1877. And so the person that lost one of the central battles of the Civil War in Selma, a person who I've traveled to Selma a number of times, and I've been in the modern day, and I've been interested to see how many tributes there are to Nathan Bedford Forrest in Selma, very often visible as you walk across the Edmund Pettus Bridge to commemorate the march that happened later. There's a statue that used to sit of Nathan Bedford Forrest right under the bridge that the marchers passed over in 1965, and John Lewis would lead a trip every year, and that statue sat there for a long time. And then I remember when I was a lawyer at LDF, I traveled and I learned of the statue and learned how prominent the founder, the first Grand Wizard of the Ku Klux Klan, is memorialized under this bridge to freedom that we all extol as part of civil rights. And thinking about the discontinuity, the first time that I took the trip there, I was working on the Reauthorization of the Voting Rights Act. And we're going to come to that and talk a little bit about how this all grew out of the later march. But I remember feeling that it was a little jarring that these two things could exist in the present day in one space in that way. And so it really struck me. I was working on the Voting Rights Act reauthorization, and there was a big billboard, the first billboard after you walked over the Edmund Pettus Bridge in the direction that the marchers took on the day of the beating, and then later when they did the march again after the beating. And the first billboard that you saw after you crossed the bridge was a poster that said, "Visit the historic sites of the Civil War." And it was a picture of Nathan Bedford Forrest on the billboard, a big, big picture of Nathan Bedford Forrest with the quote, "Keep the scare" on him. So it was a picture of Nathan Bedford Forrest on the anniversary of the Voting Rights Act in 2005. We're working on the reauthorization in Congress to talk about the need to continue to have protections in place. And in the place, in a sense, where the movement happened that catalyzed the passage of the bill, while we're working on the legislative piece, in big lights is Nathan Bedford Forrest. Now, I was so shocked about this when I experienced it that I asked somebody to take a picture. I wanted to capture that image because I wanted the congressional record to reflect. There's a narrative about how everything's passed. It's behind us, that these things aren't alive, and I just wanted to show people what it looks like on the ground in Selma, Alabama at that point in 2006. Unfortunately, the person who did take the picture but somehow didn't get it to me. And so I returned there with my LDF colleagues some years later. Again, we were at the march, and I was explaining to them how jarring the experience was of encountering Nathan Bedford Forrest, a poster with that quote, "Keep the scare" on him, knowing what his history had been, knowing that he was the founder of the Ku Klux Klan, knowing how important that bridge crossing was, that it was a representation of freedom in America, but also globally about what could happen through nonviolent protest in the face of violence. And as I was telling the story, we're walking over the bridge. Sorry, this is a bit of a diversion, but it's something that left an impact on me. I'm telling my colleagues this story, and as we're walking over the bridge, that billboard is still, the placard is there, but there's a different message on it. And this time, there was some like monetary amount on it or something, and it was an ad leading to the apprehension, announcing a reward leading to the apprehension of the people who had defaced the statue of Nathan Bedford Forrest that sat under the bridge. And so as I was coming back, and so you see that these issues were being contested in real time, right? That right there, it's not an accident that billboard is right there at the foot of the Edmund Pettus Bridge, right? That's not happening by accident, and that contestation was happening, right? The stuff that Alex Kesar talks about in his book, Action and Reaction. And so Nathan Bedford Forrest certainly kept at it until the time of his death. But there's also a question, because it was more than Nathan Bedford Forrest, it was more than individuals, right? It was sort of what were the structures, what were the other events as law students, as folks that are thinking about the law and the role the law plays. How did we come to have such a long journey from these Reconstruction Amendments to the Voting Rights Act in 1965? What was happening? And I think we have to consider a series of Reconstruction era cases that the U.S. Supreme Court decided. Some of these cases may be known to you. If not, take a look at these cases and think about what was going on in these cases and try and imagine whether you think they measure up with and are consistent with the goals and the words of the Reconstruction Amendments or not. The cases that I want to mention are U.S. v. Reese. That Reese was a case in which a black Kentucky man had attempted to pay a poll tax to vote. Now, Poll taxes would later be banned and are considered anathema and the enemies of democracy. But in those days, poll taxes were the coin of the realm, and he tried to pay his poll tax, but the election workers would not accept his poll tax. And so he brought a case under the Enforcement Act. This was an act, one of the first acts of Congress designed to enforce the Reconstruction Amendments. You are law students, you know that the Reconstruction Amendments, they have the substantive provisions in them about what they're doing, and then they have a provision that's the enforcement provision that says Congress shall make laws to enforce the big idea that's above, right? Each of them proceeds in that way. The Enforcement Act was one of those such acts, right, in 1870, and so he brings a case under the Enforcement Act, but the Supreme Court struck down a provision of the act as exceeding congressional power, noting that the 15th Amendment does not create a right of suffrage. In a later case, U.S. v. Cruikshank, another one that you may have heard of. If not, please look it up. It's worth knowing about. The issue of the post-Civil War rampant violence that accompanied elections and their aftermath was at issue. After the 1872 election, the Colfax Massacre had been described as the worst instance of racial violence during the Reconstruction. After a siege at a courthouse occupied by African Americans, a white mob full of former Confederate soldiers who had sworn to see the day's struggle, this is a quote, struggle for white supremacy, close quote, through, even at the risk of facing execution by the federal government as traitors, killed 60 African Americans and 100 more in the days that followed. In the words of the New York Times, the mob was described as, quote, positively appalling in their atrocity and would appear to be more like the work of fiends than of civilized men. Another prosecution was brought under the Enforcement Act, that act trying to enforce the Civil Rights Amendments. And the language of the Enforcement Act that was at issue prohibited conspiracies to injure, oppress, threaten, or intimidate any citizen with the intent to prevent or hinder the exercise and enjoyment of any constitutionally or federally granted right or privilege. 7 of the 98 mob participants were tried. There were 3 convictions that were appealed to the Supreme Court to answer the question about whether the federal indictments were valid under the Enforcement Act. One core holding of the Supreme Court was that the 14th Amendment did not protect U.S. citizens against private action. The 14th Amendment, and thus the Enforcement Act that was trying to regulate the behavior of these people that set upon the mob at the courthouse after the election. It was in the wake of an election in Louisiana, and in the Reconstruction elections, there was diversity in legislatures and things. It was really a changing. Some things started to change really quickly, and this was what precipitated the mob violence in Colfax, and essentially the court neuters the amendment and the Enforcement Act. And we ask why was this significant? The ruling was read as green-lighting the reign of terror of the Klan, and the decision gutted the Enforcement Act, and arguably the reach of the 13th, 14th, and 15th Amendments was greatly narrowed. The leading historian of the Reconstruction is Eric Foner, and he wrote that, quote, the decision rendered national prosecution of crimes committed against blacks virtually impossible and gave a green light to acts of terror where local officials either could not or would not enforce the law. There's another book specifically on the Colfax Massacre that's called The Day Freedom Died. That's written by a Washington Post reporter, Charles Lane. And I was once speaking to Charles Lane, and he was talking to me about the Colfax Massacre and how awful it was, and the Supreme Court ruling, and what the role was of the Supreme Court ruling. And he told me that he wrote that book because the Rehnquist court had cited the Cruikshank case in an opinion. This was probably in the late 1990s or early 2000s. The court had cited the Cruikshank case in an opinion of the court. I don't remember the specific context. And he, knowing something of the history, was so horrified that the court was citing that precedent, the Cruikshank case, that he wanted to write a book so that the world would know what happened in Cruikshank, right? And that it was such a disappointment that the court would go in that way. And that's what motivated him to write The Day Freedom Died, about the Colfax Massacre. It was a mixed bag in the post-Reconstruction period when the final Union troops were withdrawn from the South, but things got bad pretty quickly. Just 12 years after the end of the Civil War, Southern states were reinstituting the pre-war social order, and white Southern elites had returned to power. And intensified the assault, predictably, on voting rights as the troops withdraw, as these acts of these judgments of the Supreme Court are sort of creating the context for the reign of terror, as the historians have accounted. And the stunning change in fortune for Black Americans, particularly in the South, can be seen through a few different lenses. One is the Black voter registration and how it went up and down. Another is the Black political representation. And another is this gap between what was guaranteed in those amendments and the post-war legislation and what was actually permitted to occur, and this is one of the topics I've been talking about, by the courts that are interpreting these things. What role do courts play in the birth of freedom? What role do courts play in this historical pattern of progress being met by retrenchment is a fair question to ask, and a long-standing one. Voter registration and turnout in that Reconstruction period was many times as high as it had been in the early years, many times higher than it had been in the early years of the Civil War. By 1910, for example, virtually all Black voters were eliminated from the rolls. And let's look at what happened in Louisiana just as one example, and because that was the place where the Colfax Massacre happened. In 1888, the voter registered population of Louisiana was 50% Black. There were 127,923 Black voters, 126,884 white voters on the rolls in 1888. At the time, these were all men because we hadn't yet had the equality amendments of gender, right? So this is when I say men in this context, it literally is, the voters are men. But as a race matter, it was essentially a 50-50 split, which reflected the demographics of the state at that time. Just over 20 years later, in 2010, the demographics of Louisiana had not changed much, but there was a precipitous drop in the Black male voter registration. In the entire state, there were only 730 Black men remaining on the voter rolls, which was less than 0.5% of the adult male population. And if you look at this by parish, Louisiana has 60 parishes at the time. In 27 out of 60 parishes, no Blacks were registered at all. In 9 out of 60 parishes, 1 Black man was registered. And this was all accomplished by focused purges and the policy in the Reign of Terror. What happened in Crookshank became the coin of the realm. There are statistics about Black politicians, including the first Congressman, Hiram Revels, in 1870, and the progress that went forward from there. But I want to move to one more Reconstruction era case, because it's not so much what the case held. I want us to focus on the language of the case and how we look forward about the way that language lives and some of the decisions that we see today and some of the controversies we see today. The case that captures some of the Supreme Court's hostility to the Reconstruction movement in a way probably just as powerful, maybe arguably more so, because it takes down the edifice of legal reasoning in some ways, is a set of cases that were called the Civil Rights Cases in 1883, a series of 5 cases in which the Supreme Court says that the 14th Amendment prevents states, not private individuals, from discriminating by race. The 1875 Civil Rights Act provided that the full and equal enjoyment of public accommodations shall not be denied based on race. The 1875 Civil Rights Act was struck down because, according to the SCOTUS, the 14th Amendment did not give Congress the power, again, to outlaw private actions of racial discrimination, right? So this is familiar. This is the same thing. The Reconstruction Amendments say this is what we're doing. We're doing it after a war. This is the body of government that we give the power to enforce it through appropriate legislation. And then you have the court cutting back these efforts of Congress, a pattern of the court cutting back. But what was the language in the opinion? This is the language from the Civil Rights Cases. When a man has emerged from slavery, now understand, when this case is being talked about in 1875, the people who have emerged from slavery are walking around. The people with the the scars of the brutality. We're not talking about a gap. We're not talking about unidentifiable victims, right? It is the moment, right? So please have that in mind as you consider these words. When a man has emerged from slavery, and by the aid of beneficent legislation, has shaken off the inseparable concomitants of that state, there must be some stage in the progress of his elevation when he takes the rank of a mere citizen and ceases to be the special favorites of the laws. And when his rights as a citizen or a man are to be protected in the ordinary modes by which other men's rights are protected. There were thousands of free colored people in this country before the abolition of slavery, enjoying all of the essential rights of life, liberty, and property, the same as white citizens, yet no one at that time thought that it was any invasion of his personal status as a freeman because he was not admitted to all of the privileges enjoyable by white citizens, or because he was subjected to discriminations in the enjoyment of accommodations in inns, public conveyances, and places of amusement. Mere discriminations on account of race or color were not regarded as badges of slavery. You know, those are the words of the Supreme Court in the civil rights cases, right? The special favorites of the laws. When a man through beneficent legislation has you know, taken down the badges of slavery. Darren Hutchinson, a legal scholar, has written about this opinion and that period in time and sort of the country's and the court's consideration of racial equality. And he has observed that less than 2 decades after the ratification of the 13th Amendment, when blacks exercised constitutional liberties under the threat of extreme violence, the court believed that Congress had provided excessive remedies for racial injustice. The court, echoing popular opinion, had reached a point of racial exhaustion. And so the reason that I want you to think about these cases and this time and what's being said at this time is because you will hear these same themes when you get to the later cases, right? When you have Northwest Austin or the cases challenging the Voting Rights Act, right? When you hear these cases, you're asking how long. When you think about the affirmative action cases, right? You hear the same thing. But when you understand that these arguments were being advanced at the very beginning, when it was manifest what the inequality was, where the victims of the injustice were identifiable and the words were virtually the same, I think it gives you a new way to look at the arguments that are being advanced today. To be sure, there are questions that are more complicated in a legal system about how you find remedies and how you match up remedies with people that are, you know, aggrieved and the victims of a particular regime or experience. But it tells us something about the sweep of history when we see that at the time when none of those factual issues are present, the rhetoric, the posts in the tent are being put down. There is a hostility in this context. And so we come back to Selma now. We move forward and we come back to Selma in the modern era. And LBJ, after the march, said, at times history and fate meet at a single time at times history and fate meet at a single time in a single place to shape a turning point in man's unending search for freedom. So it was at Lexington and Concord, there, Massachusetts, sadly not New Hampshire. So it was a century ago at Appomattox Courthouse. So it was last week in Selma, Alabama. And my friendly amendment to LBJ's prophetic words is that, as we have demonstrated today, that time and history met in Selma more than once to shape the future of history and freedom. And why is the Selma to Montgomery March so important, and how did it come about? What we know is that when Martin Luther King won the Nobel Prize, he came back and he met with LBJ in the White House. And his entire focus was not so much on the congratulation for having won the Nobel Prize. It was a focused argument to the president that we need a federal voting measure. That was his focus in the meeting. And this is recounted in John Lewis's book. And LBJ at that time said that essentially that the country was tired of civil rights. Why? Because we had just passed the Civil Rights Act of 1964. And so LBJ, who was a deft politician and was able to get that legislation through when his predecessors hadn't, was sort of measuring what was politically possible, right? There are some people who could look at that statement that the country was tired of civil rights and think that maybe LBJ, you know, wasn't doing it, wasn't prepared to use his capital for it. But he was a very shrewd politician, and he went on in the conversation and he essentially explained that they needed to create the case. You know, he essentially said to Dr. King and John Lewis and the others who were assembled, that you have to go back and you have to build the case so that we can push it through, right? I don't think he was saying we're tired of it, it's never going to happen. I think he was saying we have to create the circumstances where we can have another big push for the next phase of the legislation. Everybody is up to their, can have their own interpretation of the conversation, but that was the conversation that happened. So what happened? They went back to Selma, and there were marches going on, because there was a very brutal sheriff there, Jim Clark, who I've mentioned, and every time folks would march and look to advance voting rights, somebody would get arrested. And at this particular time before the march, some of the activists in the movement had been apprehended, they'd been taken into custody, and there was a rumor going out that they were going to be lynched. And so a voting protest happened because these organizers, Reverend James Orange and others, were being held, and there was concern about their well-being, and a march happened. And in that march, Jimmy Lee Jackson, a military veteran, rose to defend his family when state troopers came into the place where his mother and grandmother were, and he was shot and died a couple of days later in the hospital. This military veteran who was, in this peaceful voting march set upon. This is before the Selma to Montgomery March. And the Selma to Montgomery March comes from Hosea Williams, horrified by the death of Jimmy Lee Jackson, says we should take Jimmy Lee Jackson's coffin and we should march it all the way to Montgomery. And that was sort of the birth of this idea of having a peaceful march from Selma to Montgomery. It was predecessor voting marches. It was preceding activism in this place that had led to the next thing. And that was what gave birth to the march. And they also knew that Jim Clark was a vicious man. He had a reputation for being incredibly vicious. And so they knew what was coming. In the documentary Eyes on the Prize, there's a great piece, a very, very troubling but historically significant piece, is probably a better way to explain it, of Reverend C.T. Vivian, one of the activists who we lost very recently, walking up to the courthouse with people elegantly dressed, trying to register people to vote. And Reverend C.T. Vivian is confronted by Jim Clark. This is all on video. You can see it. It's in the Eyes on the Prize documentary. The Bridge to Freedom is the name of that episode of Eyes on the Prize. And C.T. Vivian, incredibly eloquent guy, comes forward and to explain that we're here to vote. We're here to exercise our rights under the Constitution. And he gets told to move back. The police officers are there. They're pushing them back. They have the billy clubs. Jim Clark used to wear a particular helmet that you probably saw on the Edmund Pettus Bridge that you might have seen in some recent marches in other contexts. And they're pushing folks back. And C.T. Vivian keeps pressing the case. He's physically being pushed back, but he keeps making the point, right? These people were very courageous. And on film, you see Jim Clark lose his temper and punch C.T. Vivian right in the mouth, right in the kisser. And C.T. Vivian begins to bleed because he's just been hit hard in the face, and he's bleeding, and this is on camera. And C.T. Vivian continues making his case, undeterred, and says, we're prepared to be beaten for democracy. We're prepared to bleed for democracy. All of this captured on video. And that moment, I think, captures the resolve of what those people who agreed to march in Selma understood in their mind. Like, when you think about what were they doing, how were they thinking about it, watch that clip of Reverend C.T. Vivian and know that everybody that showed up that day was of that mindset and was prepared to leave it on the line for the Voting Rights Act. The march was important. It happened on the night that Judgment in Nuremberg was being shown on network TV. There was no cable. Everybody sort of watched the same thing. So this event about a different moment in history is on TV, and the cameras cut away to capture what's happening on the Edmund Pettus Bridge. And people see it across the country. And they're horrified to see up close the brutality that some people knew every day, but now it's being broadcast in a broader way. And it's awakening the country to what's happening. Essentially, it was making the case, right? And what happens? Immediately thereafter, LBJ goes to a joint session of Congress and announces the Federal Voting Rights Act and the Federal Voting Rights Act bill. And the bill passes. Now, one interesting historical note is that during the campaign when Hillary Clinton and Barack Obama were contesting the Democratic presidency, they were having a bit of a debate over what how change happens, and whether it's politicians getting legislation through or activists on the ground creating the circumstances, when you look and you study what happened there, it's both. It's obviously both, right? And that conversation, that dialogue, that sequence of events talks about the nexus between creating the circumstances, the windows of legislative opportunity, and seizing them. And the Voting Rights Act was important because it was 100 years after the Reconstruction Amendments, an opportunity to have a powerful federal commitment to an inclusion principle in our democracy. It said that we were going to enforce and really live the promise of the 15th Amendment and not allow it to be a dead letter in all sorts of places. And just like in the Reconstruction era, things changed very quickly and people were registered to vote and people were elected. After the Voting Rights Act, it had an extraordinary change in legislatures, state and federal, across the country, local legislatures. People were registered to vote. Federal examiners were sent down to literally register people to vote. Maybe you've seen some of the movies. Even after federal legislation was passed, some of the local officials would not register people. And so there was a provision of the Voting Rights Act that federalized the ability, gave the federal government the ability to register people, to put them on the rolls, because they knew that the resistance would continue in some measure, right? And so all of this was to guarantee the right. And it was a transformative piece of legislation. And one of the reasons it was built in the way that it was is because there had been lots of cases that were brought. Not all of them were unsuccessful. Not all of them were blocked by the court, but they were one by one. And because the resistance was so focused and consistent and persistent and adaptive, you couldn't win the game by doing it case by case. Professor Carlin, who is now back in the Justice Department, says that it was like a game of whack-a-mole. You would stop this discriminatory voting practice here, and then there would be a court order. You couldn't do it. Then they'd find a new way to do it, pass a new law, have a new measure. Then you'd bring a case. You'd have an injunction. You get that. Then they'd find a new way. And so it was this idea of pouring old poison into new bottles that the preclearance provision of the Voting Rights Act changed everything. And it said, look, in some places, this pattern has been so consistently demonstrated and so contrary to the right to vote, we're not going to let it continue. We're going to change the rule. And what we're going to say is that in these places where we've had these demonstrations of this persistent and adaptive discrimination, we're not going to allow voting changes to happen until you come forward, until the jurisdiction, state, local, comes forward and shows that the voting change is not disadvantaging the minority population, that it is not discriminatory in intent or effect. You got to make both showings affirmatively before the measure can take effect, right? Now understand why that's important, right? In the old days, you'd put it in place, it would be the rule until such time as you could get a decision possibly to displace it. And obviously you weren't going to bring a case about everything, so some of the things just stood in place. In contrast, once you had the preclearance provision of the Voting Rights Act, Section 5 as it was called, you could not put those changes in place without having them cast aside, because you had to make that showing to the federal government, either administratively to the Department of Justice or in a case before a 3-judge court in Washington, D.C. And that was a game changer. It was one of the most effective civil rights provisions ever, because it took account of how discrimination was being practiced, and it took account of the impact of voting discrimination, which very often is class-based discrimination, meaning when you change a procedure or a rule, it has ripple effects, right? Everything is like affecting many, many people. There are individual cases. I mentioned the Reese case. You don't accept the poll tax in those days of a particular individual, that's focused. But if you have a policy of poll taxes, that's affecting a lot of people broadly. So too is the case in voting discrimination. And it was transformative. And this provision got reauthorized many, many times. It continued to block and deter discrimination, block and deter discrimination. It blocked it because you had to come forward and make the showing. If you couldn't make the showing, DOJ would say, you're out of luck, we object, you can't go forward, and then they'd have to go back to the drawing board. That pattern led to deterrence. Why? Because once that's in place, you start to understand, well, look, if you can't run that game anymore, what's the point in trying to run the game? Let's sort of do things within the bounds and not waste time, right? We have elections, we want to have elections, we want to do things. And so it became a bargaining tool in the room, even in the legislatures, right? Where you would have people say, what's the point in doing this foolish thing that's not going to go forward? Let's figure out how to do it in the right way. And that was very powerful, and it blocked and deterred lots of discrimination. So we worked on the Voting Rights Act reauthorization in 2006. The provisions of the Voting Rights Act, some of them are permanent, and in place forever. Some were so-called temporary provisions, and Congress would have to go back and see, do we still need these things? Are they still necessary? That's what happened in 2006 when Congress reauthorized the Voting Rights Act, and we were able to get a reauthorization for another 25 years. And the cases that I was involved in the Supreme Court were the challenges to the reauthorization of the Voting Rights Act and the preclearance provision. In the first case out of Texas, the Supreme Court essentially didn't reach the constitutional question. There were two claims in the case. There was a constitutional question: is the preclearance provision unconstitutional? Trying to strike it down, like those Reconstruction Era cases, beyond the scope of what Congress can do. First case, they don't reach that question. They decide on a narrow statutory basis that said that the jurisdiction that was complaining about it could apply to be exempted from the preclearance regime through a process that exists under the Voting Rights Act called the bailout. And that was the decision. So it didn't reach the big question, right? So it became sort of the dog that didn't bark, the Northwest Austin case. But the words of the opinion signaled that there was hostility in the Roberts Court to the preclearance provision that had, done such good work for such a period of time. And the follow-on case was Shelby County, where there was no statutory claim, so there was no off-ramp. The way to understand Northwest Austin, there was the big constitutional challenge and an off-ramp. Court took the off-ramp. Shelby County, no off-ramp. Only question to the court is the regime constitutional? Court says no. They don't say that you can never have preclearance. They didn't say Section 5 preclearance, which there were many opinions of the Supreme Court saying that it was okay. They didn't say that was unconstitutional. What they said is now, with the passage of time, the jurisdictions that you have identified and the way that you have identified them is not in keeping with current conditions through our court judgment, notwithstanding 16,000 pages of congressional findings. And so we're going to strike it down again, and we're going to send Congress back to the drawing board. What you're hearing today in Congress, the John Lewis Act, what you're hearing about this legislation after Shelby County, after Northwest Austin, after a recent one this term, Bronovich, is all about this continuing dialogue between Congress and the court and the ebbs and flows of access to democracy. What you saw in the last election, where certain communities were targeted, there were efforts to erase votes in particular places. There were efforts in certain places to go and make specious claims about the election. There were politicians that were talking before the election about what would happen in the election. We saw that again this week in a major state in the country, where prior to an electoral outcome, there's already, once the writing's on the wall, you start to question the process itself. And what I'm here to tell you, and what I'm here to ask as I close with you, is that I am a voting rights litigator. I am somebody who believes in the minority inclusion principle. I commit to the fundamental principle of democracy, which is what? It is that sometimes your side loses. Sometimes your side loses. That's what democracy is a commitment to. It's not a commitment to win every time. It's a commitment to engage hard in the way we do in the fields of competition, in the way we do in contests, in the way you do in your moot court, but not everybody can win. You want to advance your ideas, and there are two roads. There are two paths to winning elections in America. I've talked a little bit about them. One is democracy's high road. Mobilize voters, put out your ideas, try and bring more people out to the polls, get people excited about your vision, and be elected that way, because you have won contesting the election by virtue of the leadership presentation that you're making to the people, and you do the blocking and tackling on the ground to be elected. That I regard as democracy's high road. There is another effective way to win elections in America. I regard it as democracy's low road. And what is that? That's demobilization. That's trying to block your adversaries' people from voting. It's trying to put obstacles in the way of eligible voters so they can't be counted. It's trying to put information out there so people aren't motivated to vote because they don't believe in the integrity of the electoral process. And we are in a very serious contest on this Constitution Day, not only for the future of minority participation in elections, but for our democracy itself. For our democracy itself. At the time of the Federalist Papers, which you all know about as law students, they were making arguments about the importance of the democracy, of the constitutional democracy, and how it would work, right? It was an argument in support of the idea. I contend that what we need today is people of different parties, of different mindsets, of different races to think about a new Federalist Papers. In this conception of the rebirth of freedom, call it the next rebirth of freedom. And what would that consist of? That is going to consist of people of different views and ideologies making the case to people across the country that what is important is the commitment to the system and to the process we have of resolving our disputes through peaceful elections and allowing people's voices to be counted, including people of color, but everybody to be counted, and to creating more opportunities for that contest, and to try and win elections on democracy's high road, not democracy's low road. And my submission to you is that the choice between the high road and the low road is not only a choice about Black people, Latinx people, Asian American people, Native American people in America. It is a choice about democracy itself. And we have not only the domestic concerns about people that are willing to try and invalidate the electoral process that we saw in some very stark ways, scary ways, ways that remind us in some sense of what we saw at the courthouse in Colfax, where people are prepared to resort to violence. Right? Is it that far away when we hold these things next to each other? We need to think about what is the through line in these situations. And what I submit to you is that this fight is about the system itself and the American commitment to democracy itself. It's about the integrity of democracy and the example that America has tried to show the rest of the world. And I invite each of you to fight hard for your candidates, to get registered to vote in every election, local, state, and federal, and to win your contest of ideas at the ballot box peacefully and with great force and vigor. Thank you very much. Of course, absolutely.
AJ wants me to use the microphone.
Do you want to use this one and I can just step right here?
Well, I think I'm supposed to.
Okay, I see. I see.
Oh, there it is. Does anyone have a question?
Hi, so thank you for coming and talking to us today. So my question is about the John Lewis Voting Rights Act, H.R. 4. So recently, a group of AGs from across the country, including New Hampshire's own Attorney General, just signed a letter that attacks H.R. 4. Unfortunately, our congressional delegation supports the bill. However, I'm just wondering what you would say to the group of AGs, as well as others who are arguing that H.R. 4 undermines states' rights and the right to free and fair elections by asking states with a history of racial discrimination to have changes to voting procedures approved by the federal government.
So I would say a couple of things. I guess the first thing I would say is I would cite retired federal judge Richard Posner. Retired federal judge Richard Posner, who after the Shelby County decision wrote a blog post that you can find online where he said, you know, today the Supreme Court has struck down the historic provision of the Voting Rights Act on articulating a theory of the equality of the states, and it's a theory that I'm not particularly familiar with, and the principal reason is that it doesn't appear anywhere in the Constitution. Richard Posner, formerly of the Seventh Circuit, it was talking about the John Roberts opinion. Now, the point here is that under our Constitution, there is a role that local jurisdictions have and that states have in elections. But as I just described to you, we fought a civil war, amended the Constitution, and vested Congress with expressly granted powers to enforce the provisions of the Reconstruction Amendments, to ensure that voting discrimination isn't practiced and tolerated, because it had been for a very long time, and it's contrary not only to the interests of those people, but to the democracy itself. And there are legion Supreme Court cases that point to the appropriate power of Congress to legislate where you have this factual predicate. And so the idea that you would elevate the autonomy of states to create and allow regimes that discriminate in targeted ways against subsets of their people, and that you're more concerned with giving a free lane, like Cruikshank gave a free lane for bad things to happen, than you are to address the demonstrated problem in front of you, not a hypothesized problem that hasn't been demonstrated. The demonstrated problem in front of you with a long-standing historical root of which we've been talking about today. It's really divorced from context, and it's elevating a argument of form over substance and experience. And so I think that you look to the constitutional cases. I think you look back to Katzenbach, South Carolina v. Katzenbach, which was the first case to uphold the constitutionality of the preclearance provision of the Voting Rights Act. And then you look to the record that has been established in the 2006 reauthorization and since about what's happening. And lots of these efforts are not very, they're not very well concealed. The express purpose of discriminating against minority voters is being voiced pretty clearly in a whole lot of circumstances. So it's really a misreading of history and the Constitution to make that argument.
What would be the argument that you make to engage people in voting from either side who no longer see our election system as legitimate? How do you get them to vote if they don't see it as legitimate?
It's a very important question, and I don't think that there's one answer to that, because they're different things. They're different concerns that people that can be concerned with the legitimacy of elections may have in their mind, right? It could be that people like me never count, things don't change. It could be that there's, discrimination. It could be that the machines don't work. There's sort of a range of people that could be in that zone. But I think, what I imagine and what I sort of like to indulge a little bit of an experiment and think about what would politics look like if all of the people who don't vote, like if you break up the demographics of all of the people who don't vote, including lots of young people, if all of the people who didn't vote started to vote, wouldn't it of necessity change the things that are being talked about in politics? Wouldn't it change the range of possibilities? If people are thinking about climate change or other things, like if the folks that are giving away some collective power, right? And I understand how people think about an individual vote, will it make a difference? But when you think about how Florida was decided in the 2000 election, it didn't take a lot of individuals, right? There have been some demonstrations that narrow votes can make a difference. Do you remember how we were counting votes in the last federal election? Small number of votes can make a difference. And so I think that has been demonstrated. And then if you think about how could it change, how could it create new possibilities for politics itself? Not just the system for the system is about governance. It's about the human condition and being able to pursue our opportunities and our hopes and dreams in a context that has us on better footing than we otherwise would be. I mean, at its best. To be sure, there are problems with every administration, every set of governing folks. Nobody's perfect, right? So I'm not painting here with a magic wand. I understand that there's still work to do even after you participate, but it creates a different set of possibilities of what is possible if you were to do it. And so sometimes I think about it in that way. What would it look like if all of the people who don't vote voted, and how would it change the conversation about what's possible and in play? And Vernon Dahmer, a famous martyr of the civil rights movement, was a black man in Mississippi who had a town. He was a shopkeeper. He was a leader of the local NAACP in Mississippi, and he used to register people to vote at his store. And the Klan showed up at his house one night. They set his house on fire. He went to get his rifle and returned fire at the mob, and his family escaped out of the back of his house, and he was burned badly in standing to defend his home and trying to defend his family, and he later died. Vernon Dahmer later died in the hospital of his injuries. And what Dahmer said, I think, in the hospital as he was close to losing his life, and what is on his tombstone in Mississippi is the quote, if you don't vote, you don't count. And part of the idea is that you need to use such power as you have to count and to be counted. And I think if we aggregate our voices, maybe different things are possible.
One more, I think.
So kind of going off that last question that was asked, when we talk about expanding the electorate in this country, I think about how the United States has the highest prison population in the world. Are there any efforts, or do you foresee any efforts in the future to extend the right to vote to currently incarcerated peoples?
It's a very good question. There's been lots of litigation and some policy in this area. LDF, when I was there, worked on a whole series of so-called felon disenfranchisement cases. There are very important cases in the history of the United States, Hunter v. Underwood, which essentially showed that felon disenfranchisement was used intentionally in a way to discriminate against black people, essentially like they were picking and identifying crimes that they understood to be have black people prosecuted for more often as a tool of disenfranchisement, and it was struck down. Of course, the Constitution, be it as we take it, contemplates that there can be disenfranchisement for conviction of a heinous crime, and so there is a constitutional predicate in a sense for some measure of disenfranchisement. It doesn't mean that you have to. It's not compulsory, but it's permitted, as framed. But what we have seen is that in lots of places, there are folks that are working the angles because until you're convicted in lots of places, you don't lose your right to vote. And so if you're being held prior to conviction, there have been some cases and some efforts to get election materials and stuff to folks pre-conviction. And then, of course, we've seen very major efforts on the back end to lower the reach, to reduce the reach of disenfranchisement for people that come out of formerly incarcerated persons, including a huge ballot initiative passed on a bipartisan basis in Florida that then the legislature came back on and tried to gut, right? You see? And so the pattern of action and reaction, ebbs and flows, is something that's consistent, but I don't think that this is something that's going to go away because the demographics of how the criminal justice system interacts with race and the intergenerational effects of narrowing the electorate on account of felon disenfranchisement. There's been a great deal of study of this issue, and I think it's some of the good work that people have been doing, both the policy people and the activists on the ground, that created the circumstances for that ballot initiative in Florida. Now you have the legislature trying to take it back, but democracy is contested. That's an example, and I don't think that this issue is going to go away.
Thank you very much. As we talked about in class, some of you were in class earlier today, Constitution Day commemorates the day, the last day of the Constitutional Convention. September 17th is when the Constitutional Convention wound up in the summer of 1787. And a story is told that as he emerged from Independence Hall, somebody asked Benjamin Franklin what kind of government had been created, and he responded, "A republic, if you can keep it." And today's topic goes right to the heart of the question of whether we are going to keep our republic. It's not something that we have done a very good job on at times in our history. And I think up until a few years ago, some people thought that perhaps we were past some of the worst moments, but we may not be. And I can only say that I think that the message today and the theme that you're talking about goes to the very heart of our ability to keep our republic. And I thank you so much for coming to New Hampshire and spending some time with us today.
Thank you for having me. Thank you. I'm smiling under my mask.